Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and estate planning attorney in New York. Today I'd like to speak for the third day on Article 81, Adult Guardianship in Supreme Court. Before I get to that, if you would like to speak with me, if you have any questions, please go to Call Frank Bruno or take a look at my website, frankbrunolaw.com. So I've been speaking a little bit about the adult guardianship process. One thing that I have not mentioned is the burden of proof. So in the context of this litigation, the petitioner, the person that goes to court to allege that a person is incapacitated, that they need a guardian, the burden of proof is on the petitioner. The petitioner has to demonstrate by clear and convincing evidence that the person has functional limitations. They could be a harm to themselves or to others, and that they don't have an appreciation for that. The standard is clear and convincing. So you may have heard, television programs and through the news, criminal court cases are beyond a reasonable doubt. Right? Beyond a reasonable doubt, whether it's a criminal jury or a trial by a judge. Right? That could be also in criminal court. You could have either a jury or a judge trial. The standard is beyond a reasonable doubt, and that's as factually true as possible, right? Beyond any reasonable doubt that this fact is true. And in civil cases, the burden of proof is by a fair preponderance of the evidence. And what that means is, I'll give you an example. If you visually looked at a scale, the scale just has to slightly weigh in the favor of the person that the judge or the jury is deciding for. So statistically, I don't think that's the right way to put it, but numerically, 51%. Yeah, fair preponderance. Yes, a little bit more. Yes, I think that's true. And in civil cases, you could have a trial by judge or a trial by jury. In the context of family court, only a judge trial. In matrimonial actions, it's a trial by judge. And in a guardianship proceeding, adult guardianship in Supreme Court, it's a judge trial. But on the issue of guardianship and whether a person could be adjudicated incapacitated, the burden of proof is by clear and convincing evidence. So that's it's in between the two. It's a higher standard than fair preponderance, and it's a lesser standard than beyond a reasonable doubt. The evidence would have to be substantially true, that the trier of fact, the judge, would think, yes, it's substantially, yes, I believe that this is true. If I had to give a number, it's more than 51%, but it's hard. It wouldn't be in any law book or rule book a number. 65% true, 75% true, but I wouldn't really go that way. It's at least more than 51% because it's higher than the fair preponderance, but it's up to the judge, and they listen to the reasonable evidence, any psychiatric evidence, and the judge weighs that. So if you'd like to speak about a situation that you may have, please reach out to me. Thank you very much.